Okay, I think we've got the okay to start the seminar. Good morning to our London attendees. Good afternoon to our Asian colleagues. I would like to welcome you today to this event, which marks the start of a series. It's a series of events and a research program on the topic of law and change. It was initiated by Singapore Management University, jointly with the British Institute of International Comparative Law. And the idea is to assess and discuss on a global scale how law changes, but also how law acts as a change agent across different areas, from technology and AI to the COVID-19 pandemic. And the arrival of the pandemic basically brings those topics together. It has increased calls for AI and big data to help innovate economies out of the worst. And this transition obviously presents a number of challenges. So today's seminar provides a Pan-Asian view on how the pandemic evidence change in law and how law in times of crisis changes rights and regulatory formats in a broader sense. Now, allow me to briefly present our speakers. I start with my co-moderator and also commentator, Professor Mark Findlay, who is actually the initiator of this great initiative and program. And Mark is professor at Singapore Management University and director of the Center for AI and Data Governance. He is a honorary professor at the University of New South Wales and the Australian National University, and was professor of criminal justice in Sydney and in Leeds. So obviously his research interest is criminal law, but also legal theory, ethics, and legal education, and obviously as well innovation, technology, and the law. Our first speaker is Yong Lim. Yong is associate professor at Seoul National University School of Law. He is the co-director of the AI Policy Initiative at their Center for Law and Economics. His areas of specialty include antitrust and competition law, consumer protection, information technology, and data protection law. Yong graduated from SNU, but he also obtained a JSD at Harvard Law School. And he was in private practice before joining academia, especially active in antitrust and competition law. And he also currently serves as managing director of the Korean Association of Economic Law. Our second speaker is Jerrold. Jerrold is assistant professor at Singapore Management University and deputy director of the Center for Computational Law at their law school. He writes and teaches on law and technology with a special focus on legal tech, on computational and empirical legal studies, and tortious liability for artificial intelligence. And he also holds an LLM from Harvard Law School. And our final speaker is Nadia Alexander. Nadia is professor of law at SMU. She's the academic director of SIDRA, the Singapore International Dispute Resolution Academy, and a senior fellow at the Dispute Resolution Institute of Mitchell Hamline Law School in the US. She's also a honorary professor of the University of Queensland in Australia and holds various other appointments. She is an accredited mediator and very well known in the ADR world. She is vice chair of the mediation committee of the IBA. She's an advisory board member of the Vienna International Arbitration Center, director of the Singapore International Mediation Institute, and a member of the Standards Commission of the International Mediation Institute in The Hague. What I'm going to do, I will give the floor straight to Yong, who's our first speaker, and we would like to take some questions after each speaker, but I would encourage you to please post them as we go along in the Q&A section. So we will see your questions. They will also raise up in importance during the talk, so please feel free to post them straight away and don't wait until the end, and then we will discuss your questions after each speaker. So thank you very much to all of you for being here, and I give the floor straight to Yong. Thank you.
Thank you, Eva, for the introduction, and I'm grateful for the opportunity to talk today. I would like to use the first few minutes allotted to me by broadly talking about how COVID-19 is stimulating change in law at a high level. So my first observation is that COVID-19 has exposed fault lines in our society, both old and new, and the tensions caused by these fault lines are a major driving force behind laws in the pandemic era. So we all are very well aware of traditional fault lines based on race, gender, wealth, education, etc. But COVID-19 not only has accentuated these fault lines, it has also exposed other additional fault lines that were latent within society, some but not all that relate to access and use of technology. It has also showed us that social fault lines are far more intricate and varying than we had, I think, previously thought. We are now observing fault lines that intersect through social groups that were previously discussed as somewhat monolithic in nature. These fault lines have resulted in various legislative proposals and laws. One prominent example in Korea is the proposed introduction of a profit sharing program between businesses. The proposed amendment to the facilitation of cooperation between large and small and medium-sized business act envisions firms that have weathered the pandemic in better shape than others. These would obviously include leading tech firms, that these firms contribute to a fund that would provide assistance to other businesses that have suffered. Now, this would supposedly be achieved through various incentives such as tax breaks, among other things. So the traditional fault line would be large businesses versus small and medium-sized businesses. The pandemic, however, as we all know, did not necessarily discriminate between large and small or based on size. And so the legislative proposal does not fit well with the traditional fault line based on firm size. Now, how society identifies and categorizes these fault lines will be an important factor in whether the law successfully addresses the challenges posed by these new tensions. So that is one area that we should, I believe, observe going ahead. Now, my second observation is that COVID-19 has pushed society and individuals over the edge in terms of embracing digital technology and digital lifestyles. This digital transformation obviously had begun prior to the pandemic, but COVID-19 has markedly accelerated the pace of this transformation. For example, universities carrying out instruction mainly through online courses would have seemed ludicrous 2 years ago, for example, before the pandemic. But the higher education sector has undertaken an enormous shift in terms of adapting technology within classrooms, whether they are physical or virtual. So this shift towards online activity has created new categories of workers. They have made categories of workers more visible. For example, delivery service workers. It has accelerated the pace of displacement in certain areas. It has also expanded markets. So one example that is being discussed extensively these days is the rise of individual stock investors that rely on fintech apps. It has also created new business categories like audio social app services, etc. So these and other changes are forcing a reckoning of whether existing laws are up to task in coping with this digital transformation, and I believe will result in changes in the law. Another observation is that the increased reliance on technology during the pandemic has boosted the visibility of big tech and is ushering in a renaissance of antitrust and competition policy. Many issues that are being discussed as social challenges in the digital era, starting from displacement, hate speech, fake news, consumer manipulation, etc., either devolve around or at least are related to large online platforms, often referred to as big tech. And I use big tech in the broad sense. Now, this has thrust competition law and policy to the forefront of discussion surrounding these issues. That being said, competition law and policy is not a silver bullet or even an antidote to all of these problems, but it is likely to play a prominent role in the policy prescription, whether or not a competition agency is actually involved. Now, this could lead to new regulatory tools and authorities in the digital sector that could push the boundaries of what is conventionally deemed a reasonable and appropriate exercise of regulatory powers. So this is also, I believe, will be a big change going ahead. And finally, it is likely that exceptions to existing regulations that were allowed based on extenuating circumstances will lead to a reassessment of such regulations as we transition out of the pandemic. COVID-19, as we all know, forced governments to fast-track approvals, provide exemptions, and show quite a bit of flexibility in enforcing regulations. It turned out that at least some of these regulations were unnecessary or may have been overly strict. And so we were fine without having these regulations put on in place with regard to businesses and consumers. Now, there will likely be a pushback from industry and individuals when the government attempts to reinstate these regulations as we transition to a post-pandemic society. And so I think, again, there will be a reassessment and a retooling of regulation, hopefully in a better and smarter way. So that is my first intervention.
Thank you very much. Those are really interesting thoughts. And I wonder about the first thought you had when you mentioned the profit sharing program between businesses and the legislative initiative. So there has been a lot of legislative action around the pandemic. But I wondered, I mean, who is the best actor actually to bring about change? Is it the legislator? Is it the parties of commercial dealings? Is it maybe the judges later on in a dispute? What is your vision of that? Do you think the legislator is the right actor to bring about the change? Because you also mentioned that the society has to take up the idea of legislation in order to make it efficient. So what is your view on this?
So that's a wonderful point. So we've seen government-driven, not so much change, but stimulus-based interventions during the pandemic to assist businesses. But I think the real change or lasting effect will have to be legislated. Now, profit sharing was actually a very controversial idea when it came up. There was a lot of pushback, not only from businesses, but also, for example, the support from the public was not overwhelming. So the proposal has floundered a bit. It is still pending at the National Assembly, but it is a bit uncertain whether it will become law. So I think a lot of these programs, in order for them to really continue after the pandemic or even throughout the pandemic, will need legislative actions, and government emergency powers or government emergency initiatives, I think, will not be enough to enact change.
And you think there's no general or increased sensitivity in the society to share the burden of the pandemic? Because I have a bit the impression that you know, parties, businesses, consumers, everybody realizes that this is a situation where you actually have to share the burden, and that's also an idea or an element that can bring about a lot of change. So do you think this is the case or not so much? So it really needs the legislator to fix this, and that hasn't really sunk into the mind of the public so much?
Well, definitely the public has been more sensitized to these issues or the difficulties of not only the business community, but of small and medium-sized shops and different workers, even employees that have lost their jobs or are currently at risk of losing their jobs. The problem is that who is going to bear the cost? And so how then will society cope with or share the burden? And another legislative proposal that came out and floundered a bit was profit sharing or burden sharing between landlords and lessees. And so there was talk about, well, shouldn't landlords suspend rent or lower rent? And people or the public generally is sympathetic to the pain in society. But once it becomes the question of okay, who will start to, how are we going to apportion the burden? Then new fault lines appear, and it's not as clear cut. And so that's why I think you need legislative action rather than, so the government, it's not easy for the government to just adjudicate case by case with different individual proposals. And you eventually have to come out with a law that provides guidance on how to apportion the burden or cost. Again, that is very difficult. And so that's why many of these legislative proposals will likely be unsuccessful. But I still believe that's an important reason why legislation it will be key to any change to come.
Okay, thank you. Do we have any other questions for Yong? Okay, so then I would suggest that we move straight on to Jerrold.
Hi, good morning and good afternoon. So my name is Jerrold, and here at the SMU, in fact, we newly renamed our law school to the Yong School of Law. I focus on the intersection between law and technology, which now that I think of it, might just be another way of saying law and change. Even before the pandemic, I had been fascinated by how we might use technology to make the legal system better, fairer, and also more accessible. Previously, Yong provided an excellent overview of the many laws and regulations that COVID-19 has brought to the fore, and in the way in which it has drawn new fault lines in society. Now, for my part, I'd like to zoom in on the legal industry itself and propose some ideas here on how the pandemic has changed and perhaps will change the way law is taught and also practiced. As a start, let's consider what we mean actually by change. To me, change has two separate meanings. When we talk about change by itself, it's a correlational concept in the sense that we just need to see what happened before and then compare it to what is happening after. But when we talk about something changing something else, now change has a causal meaning. For example, if I want to know how COVID-19 has changed the law, we cannot just look at the state of the law before and after the pandemic. The question to ask is, if not for the pandemic, what would be different today? And so the comparison must be made not just across time, but also across situations in the counterfactual. So this is why I think it's important to situate our discussion of what was already happening before November 2019. Commentators more authoritative than myself, Richard Susskind, Ron Dolan, have all pointed to very powerful forces that were already at work on the legal system. In a speech given in 2017, the Chief Justice of Singapore pointed to three key trends: globalization, as firms get legal work more and more internationalized and cross-border. Second, the commercialization of law, deregulation under the Solicitors Regulatory Act, ideas like legal operations, process outsourcing. And the third trend being digitalization. Of course, as everything from data rooms to discovery and litigation increasingly gets online. And all this was already happening before the pandemic. So even without COVID-19, I suspect that these forces already provided significant economic and social reasons for the use of technology in law firms, in courtrooms. It might feel today that a lot has changed looking back, but having studied legal technology, much of what has happened does not seem, at least to me, like change in this causal sense. It only feels that way because we tend to be underinformed to some extent about the staggering technological developments in legal practice over the last 2 decades. Some in the audience may fondly remember a time, not that long ago, when paper was king and you were allowed to bill this to clients. Everything was printed. You would follow a case citation to the relevant volume and page of a physical law report. Now, if a law firm were to primarily do that nowadays, I believe a professional negligence suit will be in short order. So let me illustrate what I earlier called staggering technological developments. We studied this extensively, in fact, at SMU over 2 reports published in 2019 and 2020 on legal innovation in the Asia Pacific. I can't cover the entire report, but I will limit myself to the most striking examples. In 2017, the first paper to apply neural networks to predict legal judgments was published. The paper analyze the text of court judgments and try to predict criminal sentences. Now, even saying that today will raise eyebrows, right? Fault lines again. And perhaps more eyebrows will be raised if I add that the judgments it processed were in Chinese, and the research was done by a group of Chinese computer scientists based in Beijing. It was not until 2017, in fact, that the first paper for English court judgments on the cases from the European Court of Human Rights was put out by researchers from Sheffield University. Now, China has dramatically digitized its legal system over the past few years. In 2017, again, the Chinese courts began pushing not just for online dispute resolution, with that we are quite familiar, but for mobile dispute resolution. We might have heard of this mammoth of an app that is called WeChat. It is widely used in China. Almost everybody in China has this, and on it, you can literally do anything. You can buy groceries, you can order at a restaurant, you can buy plane tickets, book slots for the exams. One other thing apparently you can now do is to resolve disputes. In particular, the so-called internet court in the city of Hangzhou worked with Tencent, the tech company, big tech again, behind the app, to build a court app hosted entirely on the WeChat platform. So litigants can appear by video before the judge, you can file court filings, you can fulfill disclosure obligations, all on the app. And this was already happening in 2017. So the Hangzhou Internet Court's success is being replicated across China, including in key cities like Shanghai and Beijing. In February of 2017 as well, the Shanghai International Court launched what is known today as Project 206. This rather cryptic name was an ambitious and broad-ranging project to technologically modernize the Chinese judiciary. So just 3 months later, the first version of the 206 system was put on trial use within the Shanghai judiciary. And the system was fully operational in December 2018. It performs 16 different functions, including data integration, case management, document generation. It even comes with a feature that uses AI to assist criminal sentencing. Now, the Shanghai courts today use the system to handle all its cases, and the model, once again, is being replicated across China. So to be sure, my source of information here is a book written by the Chinese chief architect of the 206 system. And what one says about themselves should always be taken with some skepticism. And in this light, I might add that in Singapore, we have pursued a similar strategy of digitizing case filings and litigation since long before COVID-19. And recently have pushed out a number of online platforms targeting at resolving small claims, traffic disputes, and family disputes. So returning now to the topic of law and change, the point here is that many of the changes we are seeing today are the result of long-term forces that predate the pandemic. And to a larger degree, the pandemic has not broken the chain of causation here, so to speak. On the contrary, it has, as Yong has also mentioned, accelerated the impact of many of these things. Online courts in particular were forced upon many of us, most of us, though I will leave this topic to Nadja's more expert hands when she speaks. For now, I will just offer that to me, the main impact of COVID-19, what it has really changed is not a question of what will happen, but when it happens. And where original timelines for tech adoption typically look between 5 to 10 years, that's your typical government project timeline, post-pandemic timelines might be more of 1 to 2 years. We are looking likely to have many of these things that, that technology can bring to the law far sooner than we initially expected. And there will be serious social and ethical questions to be resolved when these things are operationalized. Concerns like how we might avoid creating some kind of second-class or economy class type of justice for mobile litigation, for example, how we might avoid bias in legal computer systems, and all of these concerns may need to be worked out far sooner than we expect. And that to me is what COVID-19 has primarily changed. And that wraps up my quick thoughts.
Thank you very much, Jerrold. I have a question on this because you mentioned this mobile app, which I find intriguing because I personally didn't know that this exists. I know a lot about different online platforms, but that there is an app actually that enables you to bring claims is quite intriguing in a way. And you also mentioned that there are a couple of ethical questions questions of bias and so on that come with it. But is the discussion on this already happening, or is that discussion delayed because the progress on technology was quicker than expected due to the pandemic? So does with the pace of technology, the discussion also take place at the same pace on ethical issues, or is that something that you expect to happen in the future?
Right. That's a great question. And as far as I'm aware, the discussion is, as usual, when it comes to legal and regulatory things, it's a bit lagging behind the implementation of the technology. So primarily, we hear about talk from bias that traces back to a lot of the American literature on, how the use of the campus system, for example, is discriminating against certain races. But I don't think the conversation was that mature yet. So in the sense that it's not yet ready to, we don't really have any concrete frameworks for regulating the use of AI in the legal industry as of yet. So it's mostly just research, mostly just discussions, and there are a lot of people who feel very strongly about this, but mostly it's, as far as I know, limited to within the American scholarship. For example, now if we talk about in Singapore, there is no law, as far as I'm aware, against using a bias algorithm. Singapore does not have a comprehensive discrimination act in the same way as the UK does. So even if the court were to be doing this, there is no technical problem, so to speak, legally. And that's something that we might have to look at. I think some of us might be aware that I think just this week, the proposed EU regulation for AI was in fact leaked on Google Drive for some reason. I don't know why, but and then it does propose a number of things, and I don't know how long it will take to come into force. Of course, in Singapore, I also don't know whether we will be following that approach.
Thank you. Do we have any questions for?
Yeah, could I jump in, Eva? I'm fascinated by some of the change issues that Jerrold raised, and it takes me back to a more fundamental question that I have about the intersection between legal service delivery and tech. I'm wondering whether you believe, Jerrold, that tech's being directed towards the right issues when we're talking about the administration of law and legal service delivery. You mentioned, for example, the Chinese situation with predictive sentencing, which is crystal ball gazing based on the use of a certain form of technology and a certain form of algorithmic equation. And then in Singapore, the big deal is with automated discovery, primarily allowing the private sector legal profession to crunch so much more data and therefore open up new markets in cases that they previously wouldn't have. But do you think that those sorts of areas are the right areas for us to be looking at and for lawyers to be talking about in terms of the ramifications of tech as it hits legal service delivery and legal process?
Well, I think that is quite a tricky question, because I think at the end of the day, there are two points of view here, so to speak. So generally in public discourse, we talk about very broad cause use cases. We say things like the use of AI in criminal sentencing, right? And whereas in the actual implementation, the specific use of AI might be a lot more limited. In the case of the Chinese courts, what they primarily use it for is to try to detect inconsistencies between two different judges. So if two cases with roughly identical judgment are fed to the system, but they result in different sentences, then the system will flag it as a statistical anomaly, and then the human judges will look at it and try to figure out whether that was warranted. So when we go to that kind of the more specific fine use case, it may seem a bit less objectionable than when we talk about a broad idea of it's just like Minority Report, where we're just trying to predict crime and everything. So I think the discussion, if you ask me whether it is right, I think it may not be right in the sense that it tends to operate on maybe mistaken assumptions of what tech is being used for. Those who are unfamiliar with tech tend to think it's this big evil AI coming after me, and the lawyers using it are complicit in the evil. Whereas the truth is a bit more complicated than that. and it's not being held by a lot of the public discourse on the stuff you see on news outlets about, is AI coming for your job? Will AI replace lawyers? That stuff isn't helping. So I think the public discourse is not right in that sense.
I have another question generally. So, I mean, the question arises if automatization is risking due process. And I think you need to find a balance and look at different types of disputes, because there are some types of disputes, such as small value consumer claims, where actually without technology, there would probably be no access to justice because the consumer would simply not bring the case to the court. And then there are other cases where obviously an automated decision wouldn't make much sense. So what is your view on that? So do we need to take a balanced view, and will there be a sort of tendency to say for those lower value disputes, the future definitely will be automatization, and there is less of a due process risk, whereas we have high value disputes with a lot of debate and a lot of principle and discretion of the judges where we actually need a proper decision? So what do you think?
Yeah, I think this is a problem with, I think, essentially what the economists call the extensive and intensive margins. So, people who are already using the product versus new people who wouldn't use the product, but for the reduction in cost. So new joiners to the market. And one of the things that a lot of access to justice advocates point out with technology is that, as the system currently is, the court system isn't working for the 85% of people cannot afford a lawyer. And they go through the court system as litigants in person, and they're put at a serious disadvantage. So usually the access to justice, the tech enthusiasts would say, okay, we need to help these people. But on the other hand, there is this true concern that, especially if we force people to use, or we make it such a sticky default that you have to use online as a means of dispute resolution, there are all these real concerns about due process as you've raised. And I think the one principle we can all agree on here is that generally we should reserve online dispute resolution for easy cases, whereas the hard cases has to be adjudicated in person. That principle, I think we can agree. The problem is we cannot agree on what constitutes a hard case and what constitutes an easy case. As we all know, it's a famous debate in legal theory. We tend to use heuristics such as high value versus low value. But a low value case might be really, really complicated. If you recall, I teach torts, and the case of Donahue and Stevenson was over a few $100. A snail in a bottle. That might be seen as an easy case to some. So, what exactly is the requirements and how we can practically implement this classification of, okay, which cases should go online versus which cases should be offline is going to be very, very difficult. So, I don't have an answer to that as well.
Thank you. Are there any other questions from the panel for Jerrold? I can't see any questions in the Q&A. I would suggest we continue with Nadia, and then I'm sure we will have further questions coming up.
Great, thank you, Eva, and thank you in particular, Yong and Jerrold, for providing such rich context. I'm going to zoom in and have a look at the way that AI is changing dispute resolution, and in particular focus on mediation, or I guess non-determinative participatory dispute resolution. But I'll start with a few general comments about dispute resolution, building on what Jerrold has said about AI and litigation. So it's not a new idea. And certainly if we think about litigation and arbitration, so determinative dispute resolution processes, we've seen AI helping with discovery, searching through masses of documentation, offering textual analyses in a fraction of the time that the humans could, and as has been mentioned, case management and decision support systems, right? Predictive models, as Jerrold talked about as well. In arbitration, arbitrator analytics is becoming increasingly used in terms of selecting an arbitrator. Now, these are determinative dispute resolution processes where you've got a third party, a judge or an arbitrator, who makes a decision based on the application of legal rules to the evidence that's available. But when you're talking about consensual dispute resolution, such as mediation, it's a very different creature. So mediation is more akin to negotiation than to arbitration or litigation, but yet it's often viewed through a legal arbitration lens. And for those of you who may be unfamiliar with mediation, it's essentially a process where a third-party mediator helps parties negotiate an outcome to their dispute that is practical, that addresses their commercial, personal interests, and that it's informed by their legal rights and obligations, but the decision doesn't have to be a legally based one at all. And so many of the comments that I'm about to make will also be applicable to negotiation, I think, as well. So in recent years, pre-pandemic, there's been a significantly increased interest in mediation, both domestic and cross-border. Why? Yes, there are benefits such as it's cost effective, it's time efficient, it can cross borders and cross cultures in ways that determinative dispute resolution processes can't. Very creative outcomes are possible that legalistic procedures may not be able to provide. And the empirical evidence shows that when people have their say, when people have a voice, when people participate and shape the outcome, even if they end up with something that they don't love, right, it's something they can live with, that they are more satisfied than in many cases than if they get a legally, from a legal perspective, a good outcome that's imposed upon them. Most recently, there's a United Nations treaty called the Singapore Convention on Mediation, which now offers for cross-border mediation a direct enforcement mechanism for mediated settlement agreements. That's also part of this momentum around mediation generally. But since the pandemic, and I think Yong addressed this point as well, there's, people have really been pushed into what I'm going to refer to as online mediation. And mediation has been referred to as a pandemic-proof process in some ways. And why? Well, it's procedural flexibility, because parties can shape, they're not just responsible for the outcome, they can shape the process to a large extent. The procedural flexibility means that AI and mediation can work together in a lot of different ways. And online mediation is just an umbrella term for countless variations of the use of tech in that process. And also with COVID, where disputes have arisen through no fault of either party, for example, through disrupted supply chains and travel restrictions, the principles of mediation, which are not fault-based, sit quite well with these type of disputes. But I might get back to that later. So what I want to highlight here is that procedural flexibility and party autonomy are paramount in mediation, and they manifest themselves in different ways compared to arbitration and litigation. And so AI can fundamentally change the process of mediation in ways that that don't apply to litigation and arbitration, and in ways that I think many service providers, and by that I mean individual mediators and institutions, right, who are now rolling out online mediation in different forms, that they haven't really thought through. And so it's not a surprise that AI is referred to as the fourth party. If you think of the third party being the mediator, the fourth party is tech or artificial intelligence, because of the power that it has to influence how the process is conducted, so procedural aspects, how parties communicate with one another, so relational and cultural aspects of the process, and AI has the ability to shape what's put on the table, how it's framed, what's discussed, and therefore the potential to have a direct impact on the outcome, right? Even though we talk about party autonomy and the parties being in charge of the outcome. Now, I'm not trying to say it's all doom and gloom, but I'm trying to say that there are real issues that need to be thought through, and that I think in many cases aren't being thought through, because we're thinking about mediation in the same way as we're thinking about litigation and arbitration. And I think that's that's not the way to go. Just a couple more comments. So, since COVID-19, I think what we've seen mainly with online mediation is what's often referred to as Zoom mediation. So doing what you would do in a physical mediation on Zoom or on Teams, or even on Skype sometimes on a platform like this. And that's been met with mixed reactions. And I think that's in part because we're trying to emulate what we do in physical mediation online without thinking, how can we make this technology or service mediation? How can we, what makes mediation desirable? What makes it attractive, right? What are the core characteristics of mediation? And how can we achieve that to the same level or even a better level, right, using technology, rather than just trying to do the same thing that we do physically online, which isn't always working because mediators can't intervene in the same way, right? Parties can't persuade in the same way. And the second point related to COVID, I think, is that online mediation is so much more than Zoom. And there have long been dedicated online mediation platforms relying on a range of different technologies, much more than this, using, for example, negotiation support systems so that parties who are trying to negotiate an outcome could benefit from a negotiation support system which would indicate what their likely outcome would be if they went to court or arbitration. And with that information, they can then negotiate as one of many, many examples. But many institutions are focused just on these type of communication platforms and are not looking to this dedicated type of technology. I think in closing, just for my initial closing comments, I want to just say that there are many benefits that technology can bring. I mean, obvious ones like crossing geographical distance, benefits such as, you can pick a mediator from anywhere in the world and not necessarily at any extra cost. If parties, aren't comfortable being in the same room, you can be in different virtual rooms, and that can be a lot easier. And there's certainly empirical research that shows that the choice between, for example, synchronous and asynchronous negotiation platforms, right, can have an impact on how emotive people are going to be, right? And that if you're using something like an email asynchronous type of platform, that many parties feel they have the opportunity to reflect and negotiate in a way that's more rational, let's say. But, the other issue is that while behavioral economics tells us, and Jerrold referred to this as well, that human beings are flawed and we aren't good at making rationally optimized choices, and AI might be able to help us with that, and remove some of the biases that we have. Is it really true that AI can remove the biases, or does it just replace the biases? There's an article by Daniel Rainey that's 1 million years old, and it's called "The Culture is in the Code," right? Which I think says it all, right? The culture and the biases of your algorithm is embedded in the code and comes, it cannot be neutral, right? I mean, it cannot be, free from bias at all. So what do we do with that? And the second risk, I think, is that there is technology now that purports to read human emotions, right? And we know that mediation is a relational process. There is technology available and used in some mediation contexts where parties can, for example, feed in to the algorithm what their interests, what their needs are, what's important to them, right? As a foundation for what would be a good outcome. Now that's based on self-information, self-reporting, but there's also the capacity for these type of platforms and this type of technology to bring in your broader digital footprint, to bring in information that you don't necessarily want there, right? The information about you that you might not have control over. And I think that's when, all of a sudden there's this big challenge of, what does party autonomy mean? What does it mean for me to be able to make a decision in a mediation? And to what extent do I lose that once my digital footprint is there, sort of being calculated as part of some AI, rational choice process? What sort of impact does that have on the fundamental core characteristic of mediation. And I'm going to stop there.
Thank you, Nadia. We have some related questions. And the first one is actually referring to what you just said before from Laura Edwards. She says, if humans are inherently biased, then the AI systems designed are certain to reflect such biases. Do you think it is possible for us to design automated systems that could actually make the legal system equitable? And that's a question to all of you, I guess. First to Nadia, but also the other speakers. Well, what do you think? Can we use this for benefit, basically?
I think, I mean, I think the path forward is for humans to stay involved in dispute resolution, and particularly in mediation. And I don't think there's there's an end answer to this, right? I think it's how we continue to navigate this tension. And that's the path I think we need to be on, and we need to know we're on this path.
Could I jump in quickly there too and just add to that? I think one of the interesting things about bias is that the majority of biases we have are usually concealed. They're hidden in our minds. They're hidden in our misunderstandings. Let's face it, it's one of the reasons 200 years ago in common law, judges were required to give reasons for their decisions, because people were starting to think, well, it just had to do with whether he liked the color of my skin or whether he'd had a good lunch. Now, one thing that AI can do, which I think is really important, and this has been shown with some of the critical research done on crime prediction in the US, is identify what those biases are and when they occur. Because let's face it, it's not the AI's fault that we have biased decision making. It's the data that's put into AI by humans who have a biased approach to the use of that data, or who participate in making that data biased. Now, information loops are possible with AI now, where AI can flag the introduction of a bias, the application of a bias on things like gender, race, age, all of these sorts of issues. And I think it's really, really dynamic that law can be given the opportunity, lawyers, judges, whoever it might, mediators, whoever it might be, the opportunity to see where bias is, to expose it through the use of information loops, and then to own up those biases in some way or other, so that the participants in the process get a chance to own the outcomes which would otherwise be concealed from them.
Thank you. Yong, did you want to comment as well?
Sure. I think the first question about can we design equitable legal systems? It's a very good question, but at the same time, I think it's important to really remember what we're trying to do here. We're not trying to recreate a King Solomon type of legal system, and we probably will never be able to do that, because we can't even agree what King Solomon would do with a particular case. So I think what we're trying to do is trying to create a better legal system, considering all the bias that human beings have, all the limitations of our legal institutions, processes, and trying to figure out whether AI can make those processes, make those outcomes better or more as we as a society deem equitable from a legal perspective. And so the goal shouldn't be, well, trying to create a perfect or unbiased system per se, because we really don't know what an unbiased system is. But I think it's really trying to narrow the goals, focus on what we can do at this time. And if we, in fact, find out or realize that the use of AI in this context for this specific task results in outcomes that are unacceptable, or at some point really creating some risks for a particular group, then we might have to even decide to postpone the deployment of AI for that task. And so that might also be one outcome. I think it's just trying to narrow down the task and really focus on what we're trying to do will help society as a whole to better adapt to AI.
Thank you, Yong. We also have a couple of questions now. The first one is a really nice comment from Annie McCartney, who says, Nadia, really enjoying this. I teach ADR and I've been using EdTech for over 10 years. I found nervousness in using tech back then, and we needed to find our confidence to drive pedagogy as key driver with tech following. And I think your comments on mediation, not just Zoom, are so relevant. This kind of legal tech too needs to find its place to support mediation if it is to be fully utilized. Fabulous this whole morning. Thanks so much. Do you want to comment on her idea?
Thank you, Annie. Yeah, I mean, I think it makes sense. I mean, we flocked to Zoom and stayed with Zoom, not, you know, for meetings, for mediation, for teaching, for, you know, for so many applications. Why? Because it's a shift for many of us, or it was a shift. And there's this principle of familiarity. We're familiar with this, right? And therefore we'll stay with this, and therefore it works. I actually thought I might even link this to the next question that I can see in the chat. Can I do that, Eva?
Yes, of course.
Because the next question is about, you know, about power differentials. And I think every single thing that we do, and I'll continue with the mediation example, every single thing that we do in the sort of the physical world, when we do the same thing on a platform such as this one, it's different, right? And of course, you know, if you're talking about power differentials, whether you're teaching or mediating, you need to think how that's different. You need to think about issues of digital literacy, digital, you know, accessibility, and I think they're real issues that many people are just glossing over right now. Yeah.
Can I step in there? Because I've been thinking about the question of Zoom hearings and litigation moving online as well from the litigation perspective, where some different issues arise as well, because there's the whole discussion around the public character of hearings that you can't maintain if you have hearings on Zoom. But also the interaction of parties with lawyers, because actually you can't really set this up in a Zoom environment the way you would do it in a courtroom. But on the other hand, so there are some difficulties here. There are less difficulties in that respect with arbitration, because where you hold a hearing has traditionally been very flexible in arbitration. And also there is no issue of the public being involved, because arbitration is confidential. So that it's easier in an arbitration setting, it seems to me, to move online than it is in a litigation setting. Nonetheless, due to the pandemic, this move has been made. And the question is, how permanent is this change? So is this going to stay after the pandemic? Because there are a lot of practicalities, a lot of practical advantages. Or are we going to move back to the normal environment? And you mentioned it for mediation, that Zoom mediation received mixed reactions. Are you thinking this is shift back to live mediation as a general rule, or will online be the general principle and exceptionally people meet live? I don't know what you think.
In terms of mediation, what I think will happen is that we'll still stay, you know, where we are for a while. I think two things will emerge. One is we'll move more towards hybrid mediation, which is using online and offline. So, for example, there's been some speculation with the United Nations Ombudsman's Office, and this is just an idea that's, you know, that's being discussed, that instead of for workplace type of disputes, instead of sending people hopefully post-pandemic, you know, to different parts of the world to mediate these disputes, but that you would rather start with some type of online mediation, then follow up with a face-to-face meeting, and then maybe continue online, for example. But the other thing that I think, and I'm hopeful will happen, which is why I feel quite passionately about this topic, is that people will become more aware of the dedicated technologies that do exist for ODR, online dispute resolution, and online mediation, and become more, let's say, discriminate a little bit more about how they use AI and bring design into the process. So I think it's a turning point, at least for mediation.
Have you actually seen more mediation happening following the pandemic? Because you mentioned there's actually an ideal mechanism for this idea of burden sharing, right? So this we argued in this direction as well at BIICL with our breathing space project, where we thought that actually mediation should be encouraged given the particularities of the situation. But has it increased since, or?
Look, I couldn't say with it, with any empirical authority, but certainly institutional initiatives to offer online mediation have increased, and certainly there are, some empirical findings also coming out of the UK, where regular mediation institutions that have suddenly had to do everything online have then asked. This is not really answering your question, though. There's more, but have certainly asked the users, would you be happy to use online again? With an overwhelming, in some cases, an overwhelming yes, but in other cases, a mixed reaction. I certainly think it hasn't slowed down, but I couldn't, with any authority, tell you that it's increased.
Jerrold?
Yeah, can I just jump in here to maybe pick Nadia's brain on whether you think we might be stuck with Zoom for the foreseeable future in arbitration, mediation? Yes, ironically, because I know when it comes to technology and law, there is this very strong preference, very strong inertia to the default. Right? I mean, as you pointed out, Zoom is not optimized for teaching. It's not optimized for mediation. It's not optimized for litigation. It's just what we happen to use when we were forced to do so abruptly, right? And one thing in technology circles is, adopting the wrong technology could be far worse than not using it in the first place, because government systems, court systems get so deeply locked into what they're familiar with that they then start to reject. Let's not use some other things because what we have is good enough. And given also that when it comes to these technologies, there's a lot of network effects in the sense that if somebody else is using Zoom, you would want to be using Zoom as well. So we might be locked into this, and I worry that we will be worse off because of it.
Yeah, I think that the gatekeepers, for example, the institutions that are offering these type of services will play a really important role here. And certainly, I think the fact that there already exist and have existed for a long time dedicated platforms makes me think that will be the next step, right? I think, as you've said, Zoom's been the default, but there's so much more out there, I mean, I just think the sooner that institutional providers notice this and start working with it, the better.
Thank you. Do we have any other questions or comments? I don't know, Yong, Mark, would you like to comment on the issues that have been raised?
I will keep mine for the next few minutes when I wrap up.
Right, so it seems we don't have any more questions from the audience, so I would give the floor to you, Mark.
Thanks, Eva. I found the presentation so far to be extremely provocative and interesting, and they take me back to an opportunity to put in a personal plug. Some years ago, I wrote a book called Law's Regulatory Relevance, which questioned whether, in fact, law was losing its relevance in the regulatory menu, whether it was actually backpedaling in terms of the way in which regulators were using other devices. And I think it's interesting that COVID has shown that in times of crisis, law really has an argument to put that it is relevant, that it is making a difference, that it is changing things. I just noted in the interest raised by what Nadia said about mediation online, offline, and the discussion associated with arbitration. Alternative dispute resolution has really taken a march on traditional law in so many ways, not simply because it is flexible and it is cost effective and it's inclusive, but also because it's not law. And I think in many ways that the situation in crisis or crises is one where lawyers, advocates of law, those who believe in law's relevance, need to start taking stock about whether in fact law is pulling its weight and whether it's not. If you look, for example, in the debates following the imposition of controls on association and movement as a result of COVID, the debates were not debates about law so much, they were debates about much more fundamental themes, issues, questions of personal rights and liberties. And it seems that in many respects, the public is not quick to revert back to law as a platform that they're comfortable with and happy with. And therein lies a problem, I think, for those of us who advocate law as a medium for change. Earlier today, I had the good fortune of working with a face-to-face, not online, thank God, focus group that was a collection of in-house counsel working in tech startups and big tech companies. And the group was asked to discuss the relationship between IP and AI. And two very interesting reflections came out of that workshop, besides many, many others. The first was the general agreement that IP was a blunt tool, that really concepts like copyright, trademark, patenting just weren't in touch or in tune with the world in which AI, big tech, big data is emerging. And the second issue was an issue which related to the way in which lawyers need to change in order to be able to more effectively address the challenges that changes throw up. Law is I think, notoriously reactionary and regressive, unfortunately, and in many respects, particularly in areas of private law, lawyers spend a lot of time trying to minimize the impact of change. They use languages that no longer have the same relevance as they once did. Property, for example. How can we talk about property in a digital world? Can we talk about it in the same way that we talked about property in the actual world? Concepts of property rights, ownership, alienation, the idea that we can own data. I mean, these sorts of concepts that lawyers still cling on to seem to be of themselves impediments to the role of law playing an effective and let's say a vigorous part in addressing change and stimulating change towards positive outcomes. Associated with that, I suppose, is the issue of how can law change things? How can it actually make that difference? Not just how can it respond to change, but how can it use change as an opportunity to change for the better? And so, for example, if I go back to COVID, there was a big debate which we participated in to some extent about what was going to happen when the vaccines rolled out. Were the vaccines going to make a fortune for the big pharma companies, or were they going to make political hay for the US and the UK, those countries that were saying that they were ahead of the pack? What was going to happen in terms of the conventional way law valued things like science for the benefit of humankind? And in fact, interestingly, we read it entirely wrong. Lawyers were debating about the nature of how IP would protect the vaccines and how the vaccines would be profitable as a consequence. And in fact, it hasn't worked out like that at all. In fact, in many respects, this debate about IP rights, the rights of the IP holder, is something maybe that could be talked about after the pandemic's over, but certainly wasn't seen as an issue in the development of the rollout of vaccines. Now, some people might say, yes, law should have intervened to make the rollout more equitable, to make the rollout more fair for the South world and societies that haven't benefited. But certainly the other impediments that might have stood in the way of that, like property rights and associated issues, have not been such a big deal. I would suggest that change, particularly global crises, and the pandemic is only one. Climate change is going to put a much, much bigger torch onto the regulatory framework than the pandemic has done. And the question will be there for lawyers and for those advocates of access to law and legal services. What contribution do we make to a better world as a consequence of that process? Now, could I suggest going back to a couple of comments that the presenters have made? Yong drew, I think, a very important line in the sand about fault lines and the fact that in many respects, the pandemic had exacerbated those fault lines. And there's no doubt about that. Fault lines in terms of the difference between technologically literate and technologically ignorant individuals, the fault lines between citizens and non-citizens, a whole range of different areas. But what's interesting here for us, I think, particularly in terms of recent research we've been doing, is this whole idea that pre-existing structural discrimination, which law has been uniformly poor in trying to flatten, have been the, if you like, the backbone of these fault lines. The discrimination that's occurred against migrant workers across the world as a consequence of the pandemic, employment law has done virtually nothing in many countries to try and deal with those fault lines. The problems for single mums who are looking after their kids at home, but they can't get out to work because they are otherwise frontline workers in the pandemic. The whole idea of the necessary infrastructure for welfare law has been ignored in recent years. Questions like the protection and institutional care of those in prison, of those in aged care institutions. Again, the law has failed in many ways to address these things effectively and equitably. And around that, we've had this introduction of the pandemic, the change that that's brought about, and the strain that's even occurred as a consequence of that in many ways. I'm encouraged to hear Yong's belief that there will be hopefully a sort of recalibration or a reassessment or a retooling of regulatory frameworks coming out of the pandemic. Let's hope that's true. Jerrod's reflections on the introduction of tech and the fact that tech was well underway in terms of legal service delivery prior to the pandemic is right, and it's right to raise that. But something that struck me very sharply when he was talking about the developments in China is the cultural location of the way in which tech is introduced and marketed in different places and different settings. I was told by someone in China recently that one of the significant drivers for the introduction of technology into courtroom deliberations is the fact that people don't trust judges in China, and they're worried about corruption, corrupt decision making. We've all known, any of us who do know much about law in China, that the status of law has for many generations been much lower than the status of law that you'd find in the West. And so the introduction of tech into these environments could be something which is considered to be curative rather than necessarily progressive. And so it's an argument, I suppose, if we're looking at the relationship between law and change, to look at it in terms of where is the context for that change and where is the context for the change agents. Finally, looking at time, and I want to give open space to other questions that might be raised. Nadia's discussion of the introduction of online technologies and the impact that they've had in relation to pre-existing flexibilities and dynamic potentials in mediation is interesting. And the idea of the AI assisted technology being the fourth party, I think, is really, really challenging. Jerrold made a point earlier on that that lawyers were well behind the technical advance in asking questions like, why is this happening? How should it happen? How does it impact on access to justice? How does it impact on things like professional liability? Those questions which are quite profound when we look at the conversion of discovery processes through technology. But I also like this idea of AI as the fourth party, because in many respects, we forget that AI is not just something that sits outside our existence, that sits outside our understanding. Interestingly, Yong raised this, the fact that there has been a rush towards location within the digital society and an embracing of digital capacity, digital communication. And in a discussion we had earlier, the whole idea of the shift in constituencies in a political sense because of the digitization of so much of governance today. Aligned with the point about AI as a fourth party, I would argue that it's much more progressive for us, I think, particularly in terms of regulation, as seeing AI as part of a community, as being within the communities within which we operate. It might be a mediation community, it might be a community of educators, it might be a community of those who are trying to ensure that due process is well and healthy. And what is AI's role to participate in that process? I think if we can see AI as part of the process of social rebuilding coming on after crises, it takes on a new role. It's not just something that can put a plug in failing economies or give some sort of stimulus to markets that are otherwise under strain. But AI can be, if we have the right data sets and the right commitment, be a partner in moving towards the way in which we see change as being important and progressive. And I'll close on this point that came up in terms of each of the presentations. We often ask too much of tech, and certainly we have missed the eyes when we look at AI. The reality is that in certain situations, as Yong reminded us and Jerrold did as well, there might be a need for law, for legal regulation, for legal service delivery to step in and say, okay, there are some areas in social engagement, in market development, in life in general, where AI is not appropriate, where AI should not be removing the human element within the decision-making process or within the situation of social engagement. And so lawyers, and certainly law, has a very, I think, a very as yet undeveloped role in being able to help society demark those areas in change in the future where law wants to roll forward. The ultimate point that I'd make in all of this is that the pandemic has shown that old-fashioned political dogma and economic models that we've believed in for decades are now under terrible strain, whether it's democracy or neoliberal economics, under great strain. And if there is great strain, then perhaps it's healthy for us, particularly as those who are interested in law and alternative dispute resolution, to say, okay, what do we do to bring about change? How do we participate in a new economic world, in the new social world in which AI has a productive role to play? And so law becomes something which, stimulates ways forward. And we're seeing this now in terms of the way in which we're changing our attitudes to private property, to data access, these sorts of themes. Law needs to catch up. And once it's caught up, I think it needs therefore to be at the forefront of possibilities for change, rather than necessarily trying to protect the things that we're frightened we'll lose as a consequence of change.
Thank you very much, Mark. And I ask the panelists and also the audience, are there any comments or questions concerning this? This is actually a very nice wrap up of what has been said before and the new ideas you raised.
If I may, Eva, I'd like to maybe go on a slightly related tangent to what Mark mentioned, and it relates to regulation. And it tracks what we are experiencing in Korea. So what has really become clear as we talk about how the regulations and how law should be changed in a digital world, what has become clear is that there are now many regulations that are legacy regulations that overlap for a certain phenomena in the digital world. So a big trend in business these days, particularly in digital markets, is that market barriers are being destroyed, shifted, et cetera. And so now you have business models or businesses that span what we would have traditionally called different markets. A result is that legacy regulations that's focused on a specific market now all apply to a certain phenomena. So there's an overlapping cumulative regulation going on. What has happened is that I think everybody agrees, even the regulators, that we should sort this thing out. The problem becomes nobody wants to say, okay, I'm backing off. So every regulator says, well, I can do a better job. And so it's very difficult to manage the situation or streamline the situation at this time. And so you have different agencies vying for the higher or the more or the jurisdiction over this phenomenon. And another tendency that has come out of this is that these regulators have started to say, okay, well, we have to change, and that change actually means gaining new authority, gaining new powers, gaining new regulatory tools. And so you have not only overlapping cumulative regulation, but you have now additional regulation slapped on as well. And I think everybody agrees that yes, regulation is necessary. There are unforeseen risks that I think create mistrust in the markets. I think also many will agree that regulation is necessary to boost or recapture that trust that is being lost or is at risk of being lost. But at the same time, this regulation, piling on regulation is actually creating a lot of costs. And that's what is currently being debated in Korea. And I think in that sense, we have to be very careful when we talk about change. And because I think once regulators latch on to change, they often interpret that to mean, oh, okay, then I'll need this, I'll need that, I'm going to add this, I'm going to expand my authority of power, et cetera. And I think what we want is smarter regulation rather than more regulation. And so just one point that I wanted to add.
Thank you. Are there other comments from the panelists? I would, yeah, Mark.
I just wanted to go quickly back to the point that Yong quite rightly made about change, that it's not more of the same or even more of something new, but rather doing things better and doing things differently. I mean, I would go back to that meeting that we had today, and one quite amazing thing came out of the discussion was an admission by a group of lawyers that it was time for lawyers to talk to other people, i.e. to talk to technicians, to talk to individuals who might be involved in other ecosystems addressing change. And if we don't do that, then those people who are at the forefront of change, the algorithm designers, the tech scientists, the data scientists, will be flying blind. You've just only got to reflect on smart contracts. That the advocates of smart contracts argue that smart contracts are beneficial because they are certain. Now, part of the problem there is that contract lawyers haven't talked to the algorithm designers and told them, well, some lawyers don't want certain terms. They in fact want flexible terms, and that the law is not necessarily black and white. It's not binary. Now, you can't blame the techs or the data scientists for not understanding that if lawyers don't talk, they don't get out there and share their views. And to some extent, we need to adopt a new language as well. I'll just throw something up which in itself could require another hour or two's discussion, which we don't have. But we've been discussing recently the notion of digital self-determination. And digital self-determination is an attempt to move into safe digital spaces and to talk about things like rights, autonomy, sovereignty in very different ways. Because the simple reality is that when you move into digital space and when you deal with digital markets, digital economies, digital societies, then you can't talk the same old constitutional language that we used to talk, 10, 15, 20 years ago. And if we keep trying to talk that language, even the good bits of that language, without considering some new ways of talking and thinking, then we're not going to be fit for purpose to be able to participate in new ways of thinking and new ways of managing important issues like rights and responsibilities.
So what's actually the best way forward? Because you mentioned earlier and now as well that lawyers need to change. It's not only the law that changes, but the lawyers need to change and adapt to new concepts and understand what, for instance, digital assets are without necessarily referring to concepts that date back a couple of centuries. So what can we actually do to make lawyers fit for this world?
Well, I'll say something quickly, and I'm sure Jerrold wants to say something because he's involved in this daily. The argument often is that we need to train young lawyers to understand coding and to understand technology and to be capable of at least appreciating what is in the black box. And I think there's an argument for that. But the same could be said about many other things that lawyers do. We should teach them psychology. We should teach them, social relationships. We should teach them cultural studies. But I think the real issue, perhaps the best answer I could give to that question, Eva, is that we have to appreciate firstly that the law itself is dynamic. And so if we want to participate in a new world, it's not just a question of getting more knowledge about what's new out there, but being able to change some of the things that we've hung on to for a very long time. And the best example of this, I think, is our concept of private property, that lawyers have made a fortune in the last 150, 200 years, primarily protecting private property and marketing it. Lawyers do that most of the time for most of their money. And this is diminishing and disappearing in terms of the current world in which we live. So lawyers might now need to become, if you like, negotiators, trying to make a better arrangement between those individuals, for example, who are not willing to consensually recognize property rights of others and want a new world of access. I mean, a simple point on this, and I'm mindful of the time, is that if lawyers simply continue to push the idea of the enforcement of property rights, and all they've got left to do that is the law of theft, then we'll become like the dinosaur. So my belief is that if we are willing to say, hey, okay, some of the most fundamental things that we relied on previously need to shift, not so much about protecting or alienating property, but stimulating responsible access, then we can deal with the process of change much more readily. So I think we've got to look into our world, look at those impediments in legal thinking, and think a bit more creatively about what they mean in new settings.
We have a question that's somewhat related, but I see that Jerrold wanted to comment. Maybe I let you go first.
I'll keep this brief. So Mark pointed out that yes, I do have some thoughts on this. And one thing, Mark, you said was, we need to train young lawyers to understand coding and programming and in fact psychology and all this stuff. I completely agree. And I would say I wish the front lines were already there, because the other problem we have is we want young lawyers to not misunderstand coding to begin with, and that's already a problem, because there's so much, shall I say, misinformation or disinformation out there from news outlets. One analogy I'd like to make is trying to learn about AI and coding from reading news articles, social media. It's a lot like trying to learn law by reading news reports of cases. You don't get the full picture and you don't get the full principles behind it. So one of the problems we have is how do we get lawyers to really understand the underlying principles in neighboring disciplines. And this often requires a formal course, formal training, which law schools generally don't have time to put into their syllabus. Nowadays, we have so much to teach that if you tell me that I need to make a compulsory course in Computer Science 101, it might not sit very well with the curriculum review committee, let's just put it that way. And you mentioned another point, which I completely agree with, is that the law itself is dynamic. We need to think about how we can change things. And I think one other thing we might think of changing is this this concept of really how we teach law in this case-based model that comes all the way from the time of Christopher Langdell. I was reading this paper, in fact, just earlier, that talks about how this model of teaching law assumes that law is it has this disposition that is divorced from society. We can read cases, we can, without reference to societal technological developments, and we can infer some principles from the case law itself. And we don't teach students about what was happening in the social context at that time. We just read the cases and the principles come to us. So that's one thing that we might have to rethink in light of this new shift towards interdisciplinary education. And I'll just leave it there.
Mark, did you want to reply to Jerrold?
Actually, I was in full agreement with what he said, and I wouldn't have said it better. But I like Jocelyn Scott's point to some extent, that we not only need to talk to other disciplines, we need to talk to other stakeholders. I mean, she's right. I practiced in the criminal jurisdiction for many years, and the majority of my colleagues never even talk to their clients. I remember seeing an accused once say to his lawyer, "Is it over?" when the trial was concluded, because no one had said a word to him. So I think we need to reach out to not only the immediate stakeholders who are participating and affected by change, but also to sharpen up on new tools to be able to do that. We
also have an interesting comment and question from Kwong EC, which is very philosophical. The comment is: appreciate the discussion with regard to the overarching structure of the relevance of law to life. Something I'm learning is that the origins of the civil law and the criminal law come from the Noahic Covenants, Governance Codes, Retributive Justice, and the Mosaic Covenant, 10 Commandments, respectively. Accordingly, since there's a chronologic process of revelation between both, biblical theology, the progression and interface between the function of law as a tool of governance and the function of law as a tool for justice is interesting. Subsequently, with regard to the relationship between law and change, perhaps this applies to the function of law as a tool of governance rather than the function of law as a tool for justice. Very interesting comments. Do you have any reactions to this?
Just a quick reaction, which would take, again, a lot of time to explore. I think the distinction between law as a tool for governance and law as a tool for justice is exactly right and tragic. And I think in some respects what we need to be doing, particularly when we're talking about a new world into which we're moving, is not to lose the normative values of law, the things which are profoundly valuable in the way in which we market the legal values, while at the same time realizing that there are pressures to produce new ways of governing, new ways of creating social order, which ultimately should not deviate too far away from that normative frame. I'm a great believer in the fact that one of the greatest values in law is that we have a normative framework which we can celebrate. Maybe all contracts are not like the normative framework of contract law, but we've still got that framework there. And I think that that's vitally important. So justice and governance need to move together as best they can in the development of change.
Thank you very much. Are there any final statements from the panelists? Because otherwise I think we can probably close this session. It was a very, very interesting debate. Thank you as well to the audience for raising interesting points and interesting questions. And I would like to thank all our speakers for joining this debate. I want to mention to the audience as well that this debate is ongoing. So we are very interested in views, and we will follow up in the series of events on law and change I mentioned with further events in due course. So please check in from time to time and see what the next events are about. And we hope to see you soon again. Thank you very much.